Welcome. This presentation is available for MCLE self-study credit. If you would like to receive credit, you must take 3 actions. First, click Show More text below on our YouTube page. The text will expand and show a link to download the handout materials. Once you finish watching this presentation, please click the quiz link to receive self-study credit. Once the quiz is successfully completed, you will receive a certificate via email within 72 hours. We hope you enjoy the presentation. Thank you.
And thank you very much for joining us this evening. And I'm going to introduce our moderator for today, Len Levy. Len is a full-time mediator and arbitrator with ADR Services, Inc. He is a mediator in arbitrating matters in a variety of areas, including personal injury, mass tort, employment, business disputes, insurance, construction, real estate, and commercial law. Len's practice as a neutral draws up his 27 years of experience as a mediator and arbitrator, as well as his background as a litigator for almost 30 years, handling complex litigation matters. He's also been an adjunct professor of law at Loyola Law School, where for more than 13 years, he has taught a course on negotiations. He is also a host of a podcast titled Masters of Dispute Resolution. Thank you, everyone, for joining us, and I will hand it over to Len.
Thank you very much, Anna. I appreciate the introduction and welcome everyone to what I hope and I am certain will be a very informative imparting of knowledge about things you need to know about fire and fire claims. Wildfires can cause significant devastation, as we know, leaving individuals and communities to face a daunting task of rebuilding their lives and properties. Now, insurance plays a pivotal role in providing financial protection, but the process of securing fair compensation is often complex and fraught with challenges. This presentation brings together experts and advocates to discuss the significant issues that must be addressed to obtain compensation, as well as suggesting approaches for overcoming common disputes in wildfire insurance claims. We're going to be addressing those issues from a variety of perspectives. First, we're going to hear from 2 attorneys, Matt Biren and Gideon Kracov, who are not here in their roles as attorneys and in Mr. Krakov's case as a mediator as well, but rather as individuals who have suffered the loss of their homes, Gideon in the Eaton fire and Matt in the Pacific Palisades fire. And both of them have encountered issues in obtaining compensation. We will also be exploring the policy provisions, statutes, and regulations that come into play when dealing with these issues. The perspectives relating to the interpretation and application of those provisions will be those of all our panel members, but primarily 2, and that is Michael Bidart and Peter Klee, who are Mike represents insureds generally, and Peter represents insurance carriers. So let me get to the introduction of our panel in a little more detail. Gideon Kracov is a distinguished mediator with ADR Services and focuses on environmental, real estate, and personal injury matters. He's a former chair of the California Lawyers Association Environmental Law Section Executive Committee. Gideon served as Governor Newsom's appointee to both the California Air Resources Board and the South Coast Air Quality Management District, AQMD, governing board. He serves currently on the adjunct faculty at Loyola Law School, where he teaches land use and dispute resolution. Using conflict resolution training, Mr. Kracov helps settlers helps explain land use and government law disputes before litigation and after lawsuits are filed. His experience includes serving as deputy Los Angeles city attorney, where he defended the city in high stakes CEQA trials. He and his in-laws are wildfire survivors. Their homes were totally lost in the Eaton fire in January of this year. Matthew Biren is the founder of Biren Law Group and has always had an interest in the law. This interest started early as a boyhood addition to television shows like Perry Mason, The Bold Ones, and Arrest and Trial, some of my favorites. The witty and intelligent portrayal of these lawyers appealed to the same competitive spirit that has always driven Matt in sports, school, and other endeavors. And after receiving his undergraduate degree from UCLA, Matt went on to pursue his law degree at Loyola University. At the end of his first year, he started clerking for a labor law firm, Levy and Van Borg, and it was there that he first saw the tremendous advantage that large corporations and insurance companies have within the legal system. Matt and his family lost their home in the Pacific Palisades fire. Michael Bidart, what can I say? He's a preeminent consumer attorney for Shernoff, Bidart, and Echeverria, LLP. Mike has made a major impact on our healthcare system and is the managing partner for the firm and leads the firm's HMO litigation and property casualty departments. Since bringing his expertise to the firm in 1986, Mr. Bidart has developed the firm's health insurance practice by successfully prosecuting bad faith disputes against insurers and HMOs. His inexhaustible efforts were showcased in 1999 with a landmark $120.5 million verdict against Aetna over its refusal to pay for care recommended by the health plan's own physicians. The case is Goodrich versus Aetna. Peter Klee is a partner in the Business Trial Practice Group in Sheppard Mullin's San Diego office. Peter's focus is defending insurance companies and their affiliates that are sued in individual actions and class actions for bad faith, fraud, unfair competition, and other torts. He has handled over 2,000 such cases throughout the country over the past 35 years. His client list includes many of the major insurance carriers doing business in California and nationwide. Peter has handled dozens of jury trials in both state and federal court and consistently obtains favorable results for his clients in these contested proceedings. Two of his jury trial defense verdicts were recognized as California's top defense verdicts of the year in 2010 and 2016. Peter is a member of ABOTA and a fellow of the American College of Trial Lawyers, which limits its membership to the top 1% of trial lawyers in the United States and Canada. He is top ranked Band 1 by Chambers USA and has also been recognized as one of California's top 100 attorneys by the Los Angeles Daily Journal and one of San Diego's top 10 attorneys by Super Lawyers. We are going to begin our presentation now with Matt Biren, who is going to describe his experience both with the fire and his insurance carrier, followed by Gideon Kracov, who will also share his experience. Michael Bidart and Peter Klee will then provide us with key provisions, issues related to underinsurance, claims handling, and other issues, as well as the parties' duties and responsibilities. These are all laid out for your reference in the PowerPoint that was supplied to you earlier, and I would recommend that you refer to that as we proceed. So, Matt, tell us about your experiences with the fire.
Sure. Thank you, Len. My experience with the fire actually started on January 1st, not on January 7th. In the about 2 o'clock in the morning, one of my sons was staying with us that night, woke me up and said he saw on television that there was a fire really close by. So we walked up the hill, walked across a fire road, walked down a couple more blocks, and we were able to see the flames, which was maybe 2 football fields, maybe 3 from our house. Um, what happened was there was a fire that had started that night that it was foggy and nobody could get up helicopters to fight it. So it was kind of getting out of control. And then miraculously, about a half hour after we got up there, the fog lifted. The city didn't send up any helicopters, but the county did. And they were able to knock that fire down. That fire became known as the Lockman fire. I lived at the top of Lockman Lane. The fire in that area, a lot of the fire covering, the ground covering, is from chaparral, and chaparral is known to burn easily. It's also known to smolder for up to a couple of weeks after the fire, after it burns. The LA fire was up there for a couple of days after the fire, but then they left. And even when were these predictions of these mammoth 100-mile-per-hour winds, and everybody knew that this was going to be a potential fire problem, they didn't come back up there until after the fire started. What happened was the winds got started the smoldering fire and started it, and it started growing, and that became the Pacific Palisades fire. I found out about it shortly in the morning and drove up there and was shocked to see the entire hill that I lived on. People were trying to escape from the fire. It was just getting going. I came around a curve and I saw 2 houses across the street from mine completely engulfed in fire. My house had walls of smoke behind it. I couldn't tell if it was actually on fire or not. There weren't any fire people up there yet. So I left because there's only one way in and out of there. And I did. The hill was already bumper to bumper with cars trying to get out. It took me about an hour and a half to get to my office because there were so many people trying to escape the Palisades because of the fire. The fire was huge. I'd never seen anything like this. When I got to my office, my guys had the TVs on, and the very first thing I saw when I walked in was my house completely engulfed in fire. NBC happened to have a news crew that got up there just probably minutes after I left and were able to film the entire thing. And no other house had that kind of coverage because the news people had to leave shortly after as the fire got completely out of control. I probably watched it burn to the ground 20, 30 times that day. And to this day, every time NBC does a story on the fire, it's my house that they show. Maybe people saw the picture of firemen carrying a clock, a grandfather clock out of a house. That was my clock. And it's one of the only things that we have from that was in the house, and solely because the firemen carried it out. So our house burned to the ground. We had absolutely nothing left. Everything that was in it, everything we owned was in it, and we had no clothes, no place to live. We tried to rent a place, but there were so many people trying to rent, it was impossible, and the gouging that was going on was terrible by the landlords. We eventually figured out we could actually buy a house cheaper. The mortgage would be cheaper on it than the outrageous rents that people were trying to charge. So we ended up relocating to Calabasas and starting our new life adventure. The part of our story on fire is obviously insurance. We were insured for years by State Farm. The amount of insurance we had was not enough, not appropriate for the size and value of the house, but it was all that was available in the area. In September of 2004, State Farm notified us that they were refusing to renew our house and virtually almost all of them in the Palisades. And I believe in Altadena too, but Gideon can talk to that. So we ended up being insured by the FAIR Plan. And the FAIR Plan has a policy that's got a monetary cap on it, which was insufficient to cover our house and to cover our possessions in the house. The only thing that's interesting is because our house burned, it was a lot easier to deal with the insurance company because it was completely gone. As a lawyer who lived in the Palisades, you can imagine I got many, many, many calls about this, and I talked to many people. And clearly the people whose houses only partially burned, and particularly the people who only have smoke damage, have problems which are just really unimaginable that they're going through, particularly the smoke victims. And so I'm happy that we're to be part of this program. I hope that we can impart information that will help the audience deal with the fires if they're victims of it. Thank you.
Thank you, Matt. Gideon had the experience of losing not one, but two houses. And Gideon, can you tell the audience what happened with what was your experience?
Well, first of all, tough to follow Matt there. I appreciate, Matt, you going through what you've been through. I know it's not easy, but I know we're all trying to get some purpose and value out of sharing our experience with others. So my name is Gideon Kracov. I'm a mediator here at ADR Services with my colleague, Len, my mentor, Len. Thanks for having me. But today I'm not here to talk about mediation technique in the real estate or commercial disputes, about de-escalation, reducing reactivity, getting the parties to focus on interests instead of just litigation positions, facilitation, evaluation, right, Len? Instead, I'm here to talk about my experience in Altadena with the Eaton fire on January 8th and up to now. There's so much to discuss, but here today, of course, to focus on the insurance issues and maybe get myself some advice from these great Band 1 experts, Mike and Peter. And maybe it can help the folks listening online with their clients, perhaps their own lives. And maybe, again, help me as I look for meaning and purpose and as I look forward to my future after what has happened. We lost 2 homes, total loss, and all the possessions and contents inside. Len will let me just set the stage a bit. One was my wife and my primary home. We had lived there for 18 months in Altadena. The home was 115 years old, sort of a pre-craftsman, arts and crafts. It's a 3,500 square foot residence with 1,000 square foot ADU, extensive gardens. It was attributed to a well-known architect out there in the Northeast, Elmer Gray. We had just finished pretty significant interior remodeling and design and exterior hardscape work. We had a big party, for those of you who know, when they opened up Christmas Tree Lane just a month before in December. The house had fire insurance through Mercury with decent coverage when you add it all up. We can discuss that more today. We have received substantial payments, maybe 60% of the policy limits, Len, and now we're working with Mercury for the rest. The home was located in the southwest part of Altadena, near the Mausoleum, if some of you know that, near Woodbury Avenue, not in the foothills. I used to say, yes, we live near a forest, but it would have to burn through thousands of homes to ever get to us. And you see how that worked out, right? And then there's my in-laws' home. That was right next door. We shared a fence. My wife was so happy. Close enough for her, but just far enough away from me for my in-laws. Just kidding, Len, I love my in-laws. It was a smaller home, 3-bedroom home built in 1975. We had just purchased it for them, Len, 2 months before the fire. My in-laws in their mid-70s lost everything that they own. That home, folks would say, is underinsured. Folks might say the extent of coverage is not sufficient to rebuild. They might say the policy is not sufficient given the size also of the mortgage loan that is currently on the property. So 2 homes, both a total loss, but a bit of a different situation for each that hopefully may be helpful as our panel discusses various fact patterns today, and a bit different from Matt's situation too, the FAIR Plan situation. So that's all for now, but happy, Len, to share more in the time we have today, almost 2 hours remaining, with the hope that it helps participants in the program. Just one last thing. We now live in Playa del Rey, a world apart from Altadena. We're living on insurance money for now. Coverage D, loss of use. My children are in college nearby at Loyola Marymount and Otis College of Art, so that's why we ended up here. So thanks a little bit, Len, for letting me share my story.
Thank you for sharing it. I know that this has been traumatic. I suffered a almost total loss of my house in the Northridge earthquake, and but there you can identify items. This is different. This is much different, and the times were different. But what everything has in common is the fact that in order to get your lives back together, you need the help of the insurance companies to whom you've been paying premiums. And I think it's going to be very helpful if the importance of insurance and an overview of what homeowners insurance that covers fires has to, what can they offer? So let's start. I'm going to start with Mike Bidart. Mike, I'd like an overview, if you would, on homeowners insurance and the fact that it's first party insurance. Is that significant?
Yes, it's very significant, and I think it's a real good idea before we get into the weeds on the coverages and the various experiences that we've all had with the particular coverages and problems that arise in claims handling, is to first back up and go up to 35,000 feet and talk about the general issues here of insurance bad faith and the origins of the tort itself, because it will drive the discussion and it will drive the determination of the merits of the case. So the first thing to remember is that I think of insurance, and again, everything I say today is from a plaintiff's perspective, and I've had actually the pleasure and the privilege of litigating cases against Peter Klee, who's talking from the defense perspective today. But I think of insurance as a product, and it's a product that's unlike any other product in the marketplace. Why do I say that? Well, every other product you purchase in the marketplace, you as the consumer are paying money for the product. So money is leaving your hands and going to the seller of the product, in this case, the insurance company. But in every other case, and when you stop and think about it, you just everything that's in your environment, the clothes you're wearing, the food you're eating, the car you're driving, everything else, you're parting with money as a consumer, but you're getting some utility out of that which you purchase. But in the case of insurance, it's the one and only product where both parties to the transaction hope that you never need to use the product. So you're paying for it. Everybody, the thousands of people, including Gideon and Matt, who unfortunately lost their homes, not one of those people bought that insurance policy in hopes that their home was going to burn down. And for sure, the insurance companies insuring them didn't want the home to burn down either, because they like a world where they can collect a premium and never have to pay a claim. And that's important to remember because it's because of the nature of that product that really we're here today discussing insurance bad faith and the possibility of claims arising out of an insurance dispute. And the rules that the courts came to recognize, it didn't happen with the state legislature or some executive order. The breach of the implied covenant of good faith and fair dealing is a very modern tort. It didn't come about until the late 50s in California for the first time. And so the tort that I deal with every day is younger than I am. And so as far as jurisprudence goes, that's very modern. And the courts came to recognize the special relationship and the need to provide additional remedies and deterrence for bad conduct because the only thing that the insurance company is selling to someone is a notion, a feeling. That is a feeling of peace of mind and protection. And so the rules that apply to this first party relationship grew out of the courts. And the two most significant implied obligations that you should be thinking about as you're thinking about your claim for insurance for a fire loss is number one, that upon receiving a claim from an insured in a case like a fire loss for a home, that the insurance company must conduct a fair, balanced, thorough, and prompt investigation of the claim with a view toward paying the claim. What I just said has never been written in any insurance policy. And that's why it's called an implied obligation. It's not an expressed obligation, but it's definitely for everybody, including every insurance defense lawyer like Peter and every insurance company that does business in the state. They know that that rule exists. And the conduct as you're reviewing a case or you're a victim of the fire that you should be evaluating is the insurance company behaving consistent with that implied obligation? The other rule that applies, and it's absolutely hornbook law in California, and that is that an insurance company must give as much consideration to the interests of the insured as it does its own interests. That doesn't exist anywhere else in a commercial marketplace with an arm's length commercial transaction. So those rules must be kept in mind every time you're evaluating the expressed obligations in the contract and not to lose sight of that. And so that's why I think it's important as a first party concept in answer to your question.
Yeah. And the slide, I think the next slide will kind of lay out there that the coverages are coverages that are directly suffered by the insured, and there's a promise to pay as you've laid out.
As opposed to a normal homeowner's policy has the first party coverages in the first section, and then the third party liability coverages in a separate section. So today we're only talking about first party property coverage for tangible assets and loss of use.
Right. The fact that it is that there are these obligations gives a bit of I'm not sure it gives power, but it gives some power to the insureds to be able to deal with the various coverage provisions. And Mike, the different coverage provisions are those things that people just readily understand, or is that something that really needs some explanation?
Well, absolutely needs explanation, because one thing I think everyone who has been around can agree to, and people who buy their policies. If you asked anybody honestly, have you ever read cover to cover your insurance policy after you purchase it or before it was delivered? No, the answer is no. People don't. A consumer never signs an insurance policy, which is another feature of this contract of adhesion. It's pre-printed, it's delivered to you. No consumer ever called up State Farm or Allstate or Farmers and said, "Hey, by the way, I was reading paragraph 10 on page 7, and I really think I'd like to negotiate that because I don't like the way it reads." Come on, it's never negotiated. It's a contract of adhesion. And so people only, if they're lucky and their policy wasn't destroyed in the fire, they begin to read the policy after the loss occurs. And that's when they come to realize the provisions that are in there, some of which we'll talk about today. For example, the obligations to itemize personal property. Most people never know that's in there until after the loss occurs, or they don't know that they have to repair and replace the real property before they can get replacement costs. All the things we'll talk about. So it's critically important that they at least, at a minimum, carefully read the policy after the loss occurs so they know what they're entitled to.
Okay.
That was my situation. Didn't review the coverages. I was just happy to get insurance in the current environment for both of these homes. But boy, do I know those policies now, Mike.
Right. That's right.
Well, and Gideon, you're coming from a place of having dealt with insurance generally and policy provisions and those things. Most consumers are not. And even after reading them, gaining an understanding often requires some input from, for example, Mike.
Len, if I can just jump in and
Sure.
add to what Mike said. I mean, Mike did a great job of laying out what the implied covenant is and what it means and how it works. But at the end of the day, an insurance company's obligations are in fact governed by the language of the contract. The implied covenant requires them to live up to the contract in a fair and reasonable way, but it doesn't require them to exceed the obligations under the contract, which goes right into the point that I think everybody was making, which is that it is important to know what the contractual provisions are if you want to know what you're entitled to and what your insurance company is obligated to give you. And insurance contracts, while Mike noted that some view them as contracts of adhesion, under the law, insurance companies, with certain exceptions, are not required to offer insurance that they don't want to assume the risk for providing. They can choose what they will offer and what they won't offer. And some reasons why certain provisions may not be in a policy is because the insurance company does not feel that that's a risk that it wants to undertake. And if it were to undertake that risk, it would probably charge a much higher premium. The things that impact what that contract language says and what the obligations are whether there are any statutes that override the provisions of the policy, or in some cases, Department of Insurance bulletins that might take precedence over the language of the contract. At least the Department of Insurance wants insurance companies to give precedence to their bulletins, even if they're not consistent with the provisions. But other than those types of exceptions, at the end of the day, insurance companies are obligated to do what they contracted to do and not more than that. But they need to act fairly and reasonably, as Mike indicated.
And a number of the provisions, as you alluded to, are mandated by statute, correct?
It's correct. And especially when we're talking about fire coverage. That is the one area in California in property insurance in which certain coverages have to be consistent or at least as beneficial to the homeowner as the statute provides, and that statute is Insurance Code Section 2071. And to the extent Section 2071 addresses a coverage issue, the insurance company's policy has to be consistent with that. And if it varies, it can only vary in a way that benefits the policyholder, not the insurance company. But it's important to recognize that Insurance Code Section 2071 does not address all the coverages that we're going to talk about today. And that's why when we talk about coverages that are not addressed by the statute, such as additional living expenses, building code upgrade coverage, how the insurance company is required to handle those coverages is going to be dictated by what the policy requires. In other words, you go to the language of the contract in order to find out what the insurance company is required to do. And not all insurance policies are alike. Well, all insurance companies have to provide provisions that are consistent with Insurance Code Section 2071. When it comes to provisions that are outside of Section 2071, you can see a broad divergence in how different policies are written with respect to those other provisions, non-statutory provisions.
All right. The understanding what the coverages are is going to play a real role in issues that we're going to be talking about later, combined limits, things of that nature. Okay, but let's talk for a second, if we will, can, about what the different coverages A and B, what do they cover? There's also coverage C and coverage D. What are we talking about? These just alphabet letter? What's going on? Mike?
Sure. Well, again, this is very, very basic, and people, average person doesn't know this when they buy the property, but in a first party policy, you're dealing with the physical structure of the dwelling, typically coverage A. And as Peter pointed out, there are differences between different carriers. That's why this presentation isn't about any particular company, but just generally what's in a first party homeowners policy. When you insure the dwelling, the policy is going to require the carrier, and this is a common misunderstanding of people. People believe that when you lose your home to a fire, that the carrier has an obligation to rebuild your home. It doesn't. The carrier's obligation is to pay you an amount of money which it costs to restore your property to its pre-loss condition, subject to the limits of your policy, which we'll get to when we talk about the various forms of replacement cost coverage. But it doesn't require the carrier to actually do the work of repair or rebuilding. Sometimes it's been our experience that the carriers blur that line, and they, for example, bring in people, vendors to give estimates, vendors to do some of the work, etc., which is confusing to people. But the obligation is to pay money, not to do the work of repair. Coverage B is typically other structures, detached garages, workshops, guest houses, etc. And then coverage C, if we go to the next slide, is ordinarily personal property. Everything that's movable, everything within your house that's not part of the structure. And again, in keeping with what Peter mentioned earlier, and that is that you need to look to your policy to see what has the carrier agreed to do and what is required of the insured in making a claim, because it is a two-way street. The obligations and the duties to behave reasonably also apply to the insured. The insured has a duty to cooperate in the investigation, There are a number of conditions in the policies that must be read to know what the obligations are of the insured in making a claim. Um, if required, a statement, if required, a declaration under penalty of perjury of what was in the home, a requirement to sit for an examination under oath, if required, requested by the carrier. Again, all of which are set forth in a careful reading of the policy. But my experience is that one of the biggest areas of confusion for insureds following a fire loss is the requirement of the itemization of what's in your home in order to capture the benefit. People see the number for the amount of coverage they have for the personal property, whatever the number is, 500 grand, 750, whatever the number is. They believe that if their house was completely destroyed and all the personal property in the home was burned beyond recognition, that now they were entitled to that number. And that's not the case. And probably the most confusing and onerous part of any first party fire claim that people go through is complying with that requirement. Because all you have to do is stop and think. And I'm sure Gideon and Matt could tell you from their own personal experience how devastating that is, how difficult it is to do. Stop and think about as you think about what's in your closet or what's in the top drawer in the kitchen under the phone. I mean, it's crazy to think that you have to do that. People don't. If they had ever read the policy going in, they might have questioned it, but nobody does. Nobody really knows that that's the requirement, but it's there.
Yeah, we're still, if I can, Mike, we're still working, both me and my in-laws, on that list. It's interesting in my Mercury policy, and my wife and I are both lawyers. If you read it carefully, it has a time limit. If it's 60 or 90 days to provide that after the date of loss. Now, there's different rules that apply when there's a state of emergency. I think it's a reasonable time. So we're getting letters from Mercury and from Sage Sure, the unadmitted carrier for my in-laws, that we have more time. But we're 9 months in, we're still working on that. One thing that we got that was helpful was sort of a template, not from the insurance company, but from our neighbors and some of the community support that we've been receiving, which is basically an Excel spreadsheet. I mean, it is 50 pages long with every darn thing you could possibly think of in your house. So it's a template, because I don't have any photos, Matt. I don't have anything. I wish I had taken photos as I was running out and evacuating, but I didn't. But that template, Mike, has helped me. But we're still about halfway through, and it's been 8, 9 months.
Right, and that template helps to refresh your recollection about what you had that you wouldn't otherwise remember.
Right.
So it's very, very burdensome, very, very onerous to do. Now, one of the things, again, I'm speaking from a plaintiff's perspective of what I see, because I'm interviewing people every day on their loss, is the carriers get to a point to where they say, tell you what, we'll just give you X percent of it, 50, 75% of your policy limit, and we were not going to require an itemization. The Department of Insurance came out with a directive that they could get 30% up to 250 without any itemization. But beyond that, people are also being told, hey, we'll pay you 75% of it or 60% of it, and you don't have to do any itemization. And because it's so difficult, a lot of people are just saying yes to that. And so they're settling for less than their policy limit just to not have to go through the hassle of itemizing it. But the reality is that's what the policy says. Loss of use is not tangible property. This is the additional living expenses. And again, there's different forms of this coverage. Some pay have pay money based upon what the fair rental value was of the home that was lost, as opposed to requiring itemization of the actual expenses, the additional expenses occasioned by having to live somewhere else. So those are the elements of the first party coverage.
I would like to get Matt's take, because I think Matt's take on itemization might be helpful.
Well, my situation was so different than most people have. Because we were insured by the California Fair Plan, we were grossly underinsured for personal property. It was like $150,000. And I had the good luck to, somebody had told me it was a good idea to walk around and photograph everything in my house. So I had done it about 3 years before the fire. We had pictures of virtually everything, except for the things we bought in the last couple of years. And I just basically sent all the 300 pictures to the Fair Plan and said, you don't need a genius to tell you this is worth multiples of $150,000. So they just paid that portion of the claim. The same thing actually happened with our property on it. An interesting story is the Fair Plan was set out an adjuster to walk the property, and they were going to try and tell me how much it cost to rebuild the house. After when they were doing that, I said, why are you wasting this money? You insured me for X number of dollars on the house. You know it was grossly underinsured. You know it burned down we've given you evidence that it burned down to the ground, and you had an adjuster out there who confirmed that. And they said, well, we've got to wait to get this done. And this is where having knowledge of the industry and understanding the concepts of bad faith, I started writing to them saying, number one, as a taxpayer, I'm appalled that you're doing this. You're wasting money. You're paying these people to reconstruct something that you know already it exceeds the amount of the coverage we have. And secondly, this is bad faith for even the Fair Plan has this obligation of good faith and fair dealing, and that you need to pay me this money now. And, I'd hate to see this turn into a bad faith claim. Mm-hmm. And they did. They paid us 100% of what we were entitled to within a couple of months. But mm-hmm. very few people are going to have that situation. The driving force of it was we were underinsured. So it made it easier to get the money paid.
Got it. Although not being fully compensated for everything you've lost.
Not even close.
Right. Okay. Well, Mike, I think you were about to go into code upgrade and ordinance and additional coverages.
Right. And these are oftentimes overlooked, or people don't understand them. But one of the important things here, having to do with code upgrade and ordinance, and we'll get into it later on, is that it's definitely part of the cost of the rebuild. In other words, if the codes have changed since the original structure was built, and if you're going to now not rebuild at the same location, but to take the money and buy elsewhere, which we'll be covering in a later slide, mm-hmm. you can't overlook code upgrade and ordinance and law coverage under 2051.5 of the insurance code. You're entitled to have that included in the amount of money that you receive to invest elsewhere. But there's separate coverage for the trees and shrubs, debris removal, should not be overlooked, because all of them, particularly when people are finding themselves underinsured, every dollar you can get, you should make a claim for it.
Well, let me interject something here, because the slides omit any mention of, at least I don't recall seeing any mention of smoke damage. How does that fit in?
Peter, I think Peter wants to start off that discussion because he's had a lot of experience with it.
Okay, Peter.
Sure. So smoke damage is damage. It's considered by most carriers as being covered fire loss. And they consider that even though the fire itself did not touch the building and cause the loss. I think the current perception in the industry today, it wasn't always that way, is that because the predominant cause of the loss is the fire, even though the fire didn't touch the building, the smoke did, and therefore they treat it as a covered fire loss. And smoke damage claims are really where I think the industry and the homeowners are in disagreement the most. And the reason why is because the question is, what actual damage to the structure was there that was caused by the smoke? Because as the California Supreme Court has recently confirmed in the Another Planet Entertainment case, and I can give that site if necessary, but that was a COVID case in which the California Supreme Court noted that in order for there to be coverage, there actually has to be a physical loss. And then after that case came down, a smoke damage case came down called Gideon versus Wawanesa Insurance Company, and they applied that concept to smoke damage. And the court noted that there has to actually be some type of damage or physical alteration to the property itself, the insured property, in order for there to be a covered loss. And that if all there is, for example, just a thin layer of soot that can be wiped off with a cloth or vacuumed up from the carpet with a vacuum, that is probably not something that's covered because the actual insured property has not been damaged or altered in a way that would make it a covered loss. And this is where we're seeing a lot of disagreement. Now, I will say that most insurance companies are treating, whether it is technically covered or not, they are coming in, inspecting the loss, and cleaning the smoke damage for homes that are within any sort of reasonable proximity of the wildfire, and in some cases, homes that are well outside of reasonable proximity. And they're doing that because I think in large part, they're doing it for the same reason that I think because they're addressing these wildfire claims with extra care because they know how significant the damage has been, how the impact it's had on the state and its citizens, the impact. I think the Department of Insurance is heavily involved. And so I think that while homeowners are having some conflicts with their insurance companies, at least in my experience, the insurance companies are oftentimes going above and beyond their actual contractual obligations, and smoke damage is an example of that, in order to resolve claims and not get into these types of disputes. But it really depends. And again, it comes down, you have to look at the policy language. I think that smoke damage claims are going to be handled in accordance with the Insurance Code Section 2071. And so if there is a loss, the insurance company can't put a limitation on that. They have to handle it as they would any other type of situation. But these types of claims require experts to come in and do careful inspections to determine, first of all, is there any smoke residue? What is it composed of? Is it composed of compounds, chemicals that could be harmful to the homeowner if it's because of the presence of those components inside the house? If it is, then that oftentimes will lead to the insurance company agreeing to move the homeowners out, put them in a rental property while they go in and clean that, and then go back and do another inspection. And only after any of these dangerous compounds are found to have been eliminated will they then bring the homeowners back into it. But we are seeing, every case is different. And in some cases that is resolving the problem. In other cases, the homeowners don't want to return to the home for a variety of reasons. They say that they should be allowed to continue living outside the home, or that the insurance company should buy them a new house on a different property. Those are the types of disputes that we're seeing here. And ultimately, the courts are going to get involved and provide some guidance. But that's kind of a general overview of the smoke damage issue. And I'm sure Mike has a lot of thoughts on those issues as well.
Well, just a few additional is that historically, I think part of the reason that most carriers are nonetheless now dealing with acknowledging that smoke damage is covered for the purpose of remediation, is that historically, with all fires, the Northern California fires and Napa and the other fires that have taken place, there was never any real dispute about that. Smoke damage was covered. Everybody knew it. It's always been handled. But some adverse case law came down just about the same time as this fire occurred, and now it's created some controversy that didn't formerly exist. And in fact, there's been litigation at the trial court level already against California Fair Plan, who specifically resisted and took the position that it wasn't covered. And I know that a lawyer named Dylan Schaefer has already had that case before the courts in LA, with the courts going along saying that there was coverage for that, and ordering that Fair Plan acknowledged that. So again, as Peter says, it's by no means yet over with in terms of what's going to ultimately be the law applying to that, but at least some carriers are paying for it.
And I'll just add that historically, most of the wildfire catastrophes involved vegetation fires. But what we've seen recently, and in particular these January 2025 fires, are what we can call urban fires. And urban fires are different because things are burning that could emit toxic substances that did not historically exist when it was simply vegetation burning. And so that has created the specter of potential health issues that historically I don't recall ever seeing. And the Department of Insurance recognized this and issued a bulletin basically stating that homes within, I think it was 500 yards, of a burning structure would need to be inspected to determine whether there were any of these toxic substances. One of the problems, it turned out, was that a lot of the people whose homes burned owned Teslas, and the batteries in the Tesla cars that burned emitted substances that were toxic. And so that was creating a potentially dangerous environment that had to be addressed by the insurance industry. But this is very different from the historical wildfires that insurance companies have handled. And it's created a whole new range of problems for which there is not any judicial guidance. The Gideon versus Wawonisa case doesn't provide guidance on things like that. So these are issues that are going to end up undoubtedly being resolved by the courts, and then that guidance will apply going forward in the future.
And the coverages that apply to it, it depends on, is it to the dwelling? Is it the walls, et cetera, of the dwelling? Is it the personal property, the furniture? What is it going to, and it also, and I think you alluded to, Peter, that people need to move out or may need to move out. Then we're dealing with ALE coverage, right?
Correct. All of those coverages are implicated. Mm-hmm. And so the question, the foundational question is whether there has been any physical damage or alteration to any of the property. And then you go from there. And that could apply to the dwelling, that could apply to the the furniture in the dwelling, clothing, and to the extent the home is rendered uninhabitable as a result of this smoke damage, and that's a huge question that needs to be resolved.
Right.
Then that could implicate the additional living expenses coverage.
Right. Let's move along to the additional coverages, and basically what I think we need to get into is the ALE question of the loss of use, ALE and fair rental value. And Mike, I'd like you to begin our discussion of that, if you would.
Okay. Well, it's really not that complicated. There's different forms of loss of use coverage. The most rigorous one for the insured is additional living expenses, where you now have to show receipts for what you're spending in a replacement property, every additional cost that you're incurring by not living in your house, meals, etc. And it's really tough on people. It's similar to documenting the personal property loss, as we talked about earlier. The the better type of coverage for an insured, in a higher form of coverage, is fair rental value, which doesn't require you to go through all of those things. That is where instead the adjuster looks at the character of the property that was destroyed, square footage, location, amenities, etc., and determines and does an evaluation with comparables to find out what would that property rent for in the open market, and cuts you a check every month for that amount based upon that property that was destroyed. So again, it requires you to go through your policy to find out, because most people, if not all, don't know what they have in that form of coverage. They learn about it for the first time after the loss.
Mm-hmm. Okay. Well, Matt, you had some experience with dealing with ALE, or may still have some experience.
Now, again, being under the FAIR plan, there's advantages, I guess, to being underinsured. They gave you a fair rental value rather than the ALE. The fair rental value was anything but that. It's an arbitrary number which they had decided to stick on your house, which was, in my case, maybe 20th of what the real fair value of the property was. But they paid it right away, because when our house burned down to the ground, they knew we were going to be out. My understanding with the ALE coverage is you can't, if you buy a house, then it cuts off them paying you for being out of the house. And we were able to buy a house because the fair rental value doesn't have that provision in it. It just, they pay you the money, period, as long as you're out of the house. So we were able to buy a house without losing any under the policy.
Yeah, my experience, and I'm in the middle of that right now. This is a situation, Mike, Bidart. I mean, by the grace of God, we have a decent coverage D limits on loss of use. I never looked at it. The first time I looked at it was after the fire. And by the grace of God, it's actually pretty strong on the main home we had, the Mercury policy. So we're in a rental. We got price gouged a little bit because we got it the day after the fire in Playa del Rey on January 9th or maybe the 10th. But one of the things, and so we have, even with the price gouge, if you maximize it, maybe 3.5, possibly even 4 years of ALE coverage. One of the things we're discussing now is, instead of taking that money and every month giving it to a landlord, whether Mercury would allow us to buy a home and use the ALE to pay the mortgage. Not the property taxes, not the insurance, not the homeowners association, but the mortgage. And we're in that discussion right now with Mercury, as the 1 year is going to be up on our current lease. I don't know if Mike or Peter, you have any thoughts on that situation.
Yeah, my thought is that because it is a deviation from the four corners of the contract, you're doing the right thing to take it up with them, not just assume that it's going to be okay and do it. You definitely want to make sure that you disclose that to the carrier and tell them what you're doing. It's a sensible request. It's no financial harm to the carrier. There's no reason they shouldn't do that as far as logically, but because it's a departure from the policy, you need to do that by agreement rather than just do it and say, hey, look, it's the same thing, pay me the money, because they could use it as a reason to cut off the benefit.
The other thing, Len, with your permission, is on this point, in normal situations, there's a limit. I think maybe it's a couple years as to how long they'll pay ALE while you're waiting to reconstruct. but I do believe in this state of emergency, we have more time. Maybe it's
Yes.
3 or 4 years.
It goes up to 3 years on the statute, right?
Well,
And it could be extended for good cause.
Right. That might be the situation I might be in, Mike.
and Matt, I think you had a question about something that Gideon just raised, which was 3 years or even the extended time with the numbers involved in the Palisades. Is that going to be would that be a problem from your perspective? Or do you have a question about it?
Yeah, certainly under the ordinance and law or law and ordinance provisions, you've got, my understanding is 3 years to give them proof that you had to pay increases. And in many cases, like my house was 50 years old in the Palisades. The contractors told me that it's going to cost, 5 times more than the policy limits to upgrade because everything's changed in over 50 years in the requirements. But you can't get paid that amount until you show them that you've actually expended the money for rebuilding. I was interested in Mike's comment earlier because we did buy. If I can show that, roll that ordinance and law over into the purchase price and get paid for it that way, then that's something I have to look into. I haven't thought of that. But what's really happening in the Palisades is there's only about 250 people who are rebuilding right now. There's about 400 people who are trying to get permitted, and there were 7,000 structures that burned. Probably 6,500 of them at least were houses. I think it's going to be 5 to 8 years before the Palisades is built to anything like it was before. And I think that many people are going to have problems if they even want to rebuild right now, getting it done in 3 years. When you look at, there's going to be problems with the competition for contractors, there's going to be, or developers, there's going to be problems with the competition for goods like metal and wood. They're going to be limited, especially with the tariffs that are now coming into play. There's going to be problems with getting the building department to issue permits and to do inspections because they're going to be grossly overwhelmed between the 2 fire areas and all the houses that are being rebuilt. And I think that anybody who's looking in the Palisades and thinking about rebuilding should really be aware of the extra time and the extra costs that are going to be involved, and really think if they want to do this right away and live in basically a construction zone, which it's going to be for the next 3, 4, or 5 years. It's definitely a problem that needs to be addressed and people need to think about.
Peter, do you have any comments on how the carriers are viewing this 3 year or those time limits and how those play into what Matt was just talking about?
Well, I have some personal views on things that I think homeowners and insurance companies both should explore, and that is whether they can reach some sort of cash compromise where perhaps the insurance company pays less than it potentially would pay if things kept going forward, but the insured is able to get payments right up front that they could then use maybe to purchase a replacement house somewhere else. And the point I'm making is that the insurance contract governs what the insurance company is obligated to do, but that doesn't mean that both sides can't try to negotiate some type of overall settlement that perhaps requires the insurance company to do something it's not required to do, but is incentivized to do because it could result in an overall lower output of funds than it would if it just ended up, for example, just as an example. So if it would cost, hundreds of thousands of dollars to just keep the insured paying ALE for years, and if the insured wants to buy a replacement house, which would cut off the ALE, mean, maybe there's room there for both sides to try to negotiate something where it's a win-win. Where the insurance company pays less money than it would otherwise pay, and the insured ends up collecting less money from the insurance company, but being able to use extra money that it would not otherwise be entitled to purchase a replacement home. Again, I want to
Peter,
point out,
Peter,
I agree with what Peter just said, but I want to caution everybody, and this was actually be for the benefit of the carriers as well. It's permissible to do that, exactly what Peter said, so long as it's the insured that is coming up with that proposal. In other words, the carrier cannot, in fulfilling its duties of good faith and fair dealing, first of all, they cannot condition a payment under a first party coverage upon executing a release, like in a third party setting. There's no obligation for a carrier, for an insured, to sign a release to get their contract benefits. However, it is also true what Peter said, that if someone, an insured, says, hey, you know what? I really want to get the extra money now up front, and if I give up some benefit in the future to get the money now, if they're the one bringing it up to the carrier and they want to do that, that's fine. It's just that that part is a one-way street, in my view.
as a practical matter, because I've made a proposal like that on the ordinance and law coverage to the Fair Plan, where I told them if they pay me half of it, I'll let them off the hook for the other half as long as you pay me right now. The adjusters generally aren't equipped to deal with those kind of suggestions.
No.
So you make one, you have to push to get up the line to a supervisor and then to a manager who's got discretion and might be able to entertain that kind of a unusual compromise.
yeah, and I really want to stress that this is an option that neither side is required to take. And so
Right.
it's not a situation where you can say the insurance company is acting unreasonably because it doesn't agree to do this deal
Correct.
that's outside the parameters of the contract. It's just one of
Right.
many ways to try to resolve a dispute or an inconvenience that the homeowner is facing on its side and the insurance company on its side.
Yeah, I mean, I'm really interested in this concept. I know we've been talking about this in the context of ALE and, potentially, negotiating, getting some of that ALE money towards, rebuilding or towards buying another property, in exchange for, not running out the clock on ALE and exhausting all of the coverage over the course of 3 or 4 years. That's coverage D. What's on the screen now is sort of this coverage A, the dwelling, and how the code upgrades and how the extended replacement cost potentially extend coverage A. I don't know if you want to go through those slides, but for me,
Len, this is Mike. Because we have two weighty areas here,
Right.
how to capture full replacement cost benefits and navigating that, and under insurance, I think we should get into this. And if you want, I can give a little historical perspective here.
I was just about to ask you to do that. Thank you.
Okay.
and then if I can, I want to tell you how that relates to my case when you're done, Mike.
Okay. So, first of all, the whole idea, there's a historical perspective here that I think people should understand, so you then understand why these policies are constructed the way they are. Until World War II, you couldn't even buy replacement cost coverage in the United States. And the reason is because it was viewed as a moral hazard. That is, that you're getting, in effect, paid for new construction when you didn't have something that was new, because every physical object has some component with the passage of time of economic or functional obsolescence, otherwise known as depreciation. Every physical asset depreciates over the course of time. You mentioned, Len, that you lost your home in the Northridge earthquake or had damage in the Northridge earthquake. I did several hundred of those cases. And I tell people to describe what depreciation is. If you had a picture of me in 1994, now you see that I've suffered considerable depreciation. And so the the idea is but the insurance industry said, we want to sell these Cadillac coverages. We want to be able to sell a product that allows them to rebuild, even though it's suffered depreciation, new for old. And we could charge more premiums for it. And so across the country, they went to the legislatures and got permission to do so. And so then it evolved to the point to where by the time of the Northridge earthquake, by way of example, the most prevalent form of replacement cost coverage that was in place at that time was guaranteed replacement cost coverage, which meant that regardless of the limit of dollars stated in the policy, that if it was more than that, they would pay no matter what the cost was. And the reality is that there was a lot of losses for the insurance industry, and it evolved then basically down to where we've got three different forms: guaranteed replacement cost, which very rare now. I've seen one in the entire experience of this recent fire. The most prevalent one is extended replacement cost, which has a limit plus an extended amount. If it goes above the limit, it could be 10, it could be 25, it could be 50, or even 100%. And so there's an example there. Or where you have just basically the base limit itself.
That would be on the next slide,
You
Dave.
calculate the replacement cost, but it's going to be limited to the base amount. But the reason I mentioned the history is because what's not contained here, but everybody's policy is different in some respects, but most policies, the way they cover the moral hazard, the standard ISO form, was that even though you have replacement cost coverage, that in order to cover the moral hazard, the insurance industry only advances the actual cash value, which by definition under these policies now is replacement cost less depreciation. So in other words, what people need to understand is that even though they have a replacement cost policy that allows them to recover the replacement cost, either guaranteed, extended, or the basic replacement cost, that they really don't get that until they do the work of repair and replacement of the property. And this is a huge problem right now in this calamity, because number one, even if you had enough insurance, even if you assume that the ultimate cost to repair your property, use the number $2 million, and you have replacement cost coverage $2 million, but now they hit you with a 25% deduction for depreciation, and they now advance you $2 million less 25% of $2 million. You have to have the financial wherewithal as the insured to put up the money or get the financing to come up with that delta to build your property. And that's even if you have enough insurance. But what the overwhelming majority of people now in this calamity are facing is that not only do they not realize they have to come up with that amount of money themselves to build a property, but the property really costs $3 or $4 million to replace. And that's what's facing people. And that's part of the problem. And as Matt was indicating earlier, people faced with the reality that they're never going to really be able to replace their property because they just don't have enough money to cover that delta in the first instance, and with the underinsurance. So I'm sure Peter Klee has a lot to say about that.
Well, I know we're going to be talking about underinsurance, which is a very big topic in this context. So maybe I'll hold back my comments until we get to that. But I think that just to flesh out what Mike means by moral hazard is that simply means you don't want to put a homeowner in a position where they would have an economic incentive to burn down their house because their house is only worth $100,000, but if they burn it down, they then can get $200,000. So they have to actually be willing to do the work that goes into putting the house up, and as opposed to getting the cash, and then that essentially was the industry's approach to dealing with that sort of so-called moral hazard. There are a lot of I don't know that depreciation is 25%, Mike, but
Well, that was an example. It's normally no more than 20%.
yeah, and sometimes far less than that. I guess it really depends on what is being depreciated in the
Right.
structure, and one way of looking at what the actual cash value is to look at what the fair market value is, and I haven't seen big problems relating to that, but maybe you and I will be having cases involving those issues in the future.
Well,
That's not one of the issues that I've seen that has
No.
created a lot of
Real quickly on that, the whole thing about fair market value, I think it bears mentioning.
Can we go to the next slide, by the way?
Okay,
Right.
is that there was a 1971 California Supreme Court case called Jefferson versus Superior Court, which said, California Supreme Court said, actual cash value equals fair market value and does not mean replacement cost less depreciation. The reality was, and that was, it arose out of a property in San Francisco to avoid a co-insurance clause, and it's complicated, but that case is now really irrelevant because by definition now, the insurance industry has for years defined in the policy actual cash value as replacement cost less depreciation, and now that's statutory in California. So that for the purposes of determining actual cash value advances under these policies, they're going to hit you with some component of depreciation. And a proper adjustment of a claim takes into consideration the age of the property and the condition of the property that was there before. Obviously, comparing me to myself in the Northridge earthquake is probably 50% depreciation, but if it's a new home that was built 6 months before the fire, they shouldn't hit you with depreciation.
Yeah, we're gonna skip ahead now, I think, to in the interest of time, to the underinsurance issues, which I think the panel recognizes as being one of the most significant of issues, because it sucks in other aspects of claims handling.
Yes.
And if is that an accurate representation here, Mike?
Yes, I do believe so. And I know Peter's going to have a lot to say about the other side of what I'm about to say, but let me give you the plaintiff's perspective here as I see it.
Next slide.
First of all, there is a very limited body of law on underinsurance in California. And there's a case called Fitzpatrick versus Hayes, 1997 case, which, if you want to understand the whole history before 1997 of this issue in California, it's a one-stop shop, great read, digesting all the case law up to there. But suffice it to say that the law in California has been, and still is that there is no duty on the part of the carrier or agents to establish policy limits or to advise as to what other coverages are available. And the case law then was, by 1997, such that there was some cases, Free versus Republic, Desai versus Farmers, et cetera, where there were certain exceptions to that traditional rule. And then Fitzpatrick versus Hayes set out the rules that applied to when does an insurance company or the agent have an obligation. And it says that they hold themselves out, they've established a relationship such that the insured relies, etc. But in a nutshell, the law, including Fitzpatrick versus Hayes, was not favorable to insureds. And so
Next slide, by the way.
making underinsured claims was very, very difficult, and it was only rare circumstances where the agent or the carrier was involved in giving advice in response to what the insured was asking. So from my standpoint, what I believe on behalf of plaintiffs, the single most significant thing that occurred was in 2010. And the most important thing that's occurred in the area of underinsurance was in 2010 when Dave Jones was commissioner. The DOI promulgated a California Code of Regulation section 2695.183. And 2695.183, at least from my standpoint, my opinion, cannot be overstated in terms of its importance. And what happened was 2695.183 starts off by saying, no licensee, and that's the insurance companies, shall communicate an estimate of replacement cost to an applicant or insured in connection with an application for or renewal of a homeowner's insurance policy that provides coverage on a replacement cost basis, unless the requirements and standards set forth in subdivisions A through E below are met. This and it's a very onerous statute, and it's too long to read here today, but there are about 20 different elements that they must take into consideration. Cost of labor, overhead profit, cost of demolition, permits, type of foundation, type of frame, roofing materials, siding materials, whether the structure's on a slope, square footage, geographic location, number of stories, materials used, age of the structure, size of the attached garage. It's a very onerous statute. Well, the insurance industry fought this. They didn't like it, and they went to court. And the name of the case is ACIC versus Jones. That case was tried in Los Angeles, and the insurance industry won. And they convinced the court that the DOI had exceeded its authority with that statute. It went to the Court of Appeal, Second District Court of Appeal, affirmed. The DOI then petitioned the California Supreme Court, and for between 2010 and 2017, the insurance industry had won the challenge to that statute. But the California Supreme Court, after granting review, came out with a decision in January of 2017, just about 10 months prior to the Napa fires, where they reversed the Second District. Speaking for plaintiffs who are pursuing underinsurance claims, this statute, it is my position, has never been complied with by the industry. For sure, it wasn't while they won between 2010 and 2017. And since 2017 and the Supreme Court decision in ACIC versus Jones, the industry, based on our experience, has not done what would be required to comply with this statute, because all of this information is not the kind of information that's captured with sending a drone over the property to take a picture of it, or even a drive-by of the property, or hiring a third-party vendor there's these companies that the insurance industry has used to come up with the values, because now it's evolved to the point to where the carriers are establishing the limits, and they're doing so in our mind based on the evidence we believe exists, without capturing all this information, because you would need to get detailed interviews and forms filled out, et cetera, from insureds in order to get this information. And so we believe that with respect to underinsurance claims, this is the single most important tool in measuring the conduct of the carrier in establishing the limits against this particular statute.
So do you expect there to be a lot of
Peter has his views on this.
Well, yeah, I think that the most significant aspect of underinsurance arising out of wildfire catastrophe is not that the insurance companies are not taking steps to try to fairly evaluate the replacement cost of the home, but rather it's because whenever there is a wildfire catastrophe, the cost of reconstructing homes goes up sometimes 50%, 100%, 500%, because there's a shortage of contractors, a shortage of materials, and the costs balloon. So step back for a moment and think, okay, well, when you are buying an insurance policy, do you want your insurance company to insure your home based on replacement costs increasing by 200, 300, 500%, and then charge you a premium accordingly? Because as we know, the more insurance you buy, the more coverage you buy, the higher the premium. Or do you want them to charge you for what it would cost if you have, your bacon on the stove splatters and causes a fire and the house burns down? Do you want to be insured for what they would cost to repair? There are competing interests there. I will simply say that if insurance companies were to charge all the homeowners in California what it would cost to replace their homes following a wildfire catastrophe, insurance premiums would skyrocket. And I don't think that most people in California would appreciate that. Obviously, people that end up being victims of wildfires, which are truly a tragedy, as we heard from both Gideon and Matthew, would wish that they had been insured for the highest possible number. But the other thing that I want to add on to that is homeowners do have typically the right and the option to say, no, that's not enough insurance. I'm worried about a wildfire event, which I've read about in the papers can increase construction costs. So I want more coverage. And they certainly are entitled to ask for more coverage and pay for more coverage if they want. But my point is simply that it isn't as simple as saying, okay, what is the reconstruction cost following the Palisades fire? Because that cost is going to be significantly higher than it would have been if there had been a single dwelling that burned down as a result of a gas fire or something along those lines. So it's a very, very difficult issue. And I think that sometimes I think insurance companies can be to blame if they haven't done their due diligence and they've made representations that are false. But on the other hand, the overall problem, the biggest problem that I see is the increased construction costs, increased materials costs that occur after a wildfire, which would not exist in the absence of the wildfire. So that's just a different perspective to think about.
And let me ask you this, both Peter and Mike, how do you see this issue being resolved? Is this going to be something the courts are going to have to say, or are we going to sit down across the table with mediation and get this resolved? How do you see it resolved?
Okay. I think, well, first of all, to my knowledge, there is not anywhere in California a reported appellate decision dealing with a verdict on an underinsurance claim for a fire loss. There may be that I've missed, but I've never seen it. The other thing is that the statute itself contemplates the need to adjust these numbers annually. Paragraph E says, the licensee shall no less frequently than annually take reasonable steps to verify that the sources and methods used to generate the estimate of replacement costs are kept current to reflect changes in the cost of reconstruction and rebuilding, including changes in labor, building materials, and supplies based upon the geographic location of the insured structure. The estimate of replacement costs shall be created using such reasonably current sources and methods. Now, but the reality of what Peter said is also true. There's no doubt but that with the prevalence now of wildfires, and I mean, you look back over the course of our lifetime, there's been more wildfires in the last 5 years than were in the last 70 years prior to that. And so it's a huge social problem, economic problem for the state, to be sure. But the statute does contemplate the need to annually update it, which, of course, from our perspective, is something that's also not complied with. We don't believe that that's done. The reason we know that is because of the number of people that we have that have policies that have been in effect for several years without any increase at all.
I just want to add one thing, and I don't disagree with the comments of Mike that if the companies are not complying with the statute, then that could be an issue that the insurance company would have to face. I'm going to give a piece of anecdotal evidence, which is I was involved some years ago in a class action against a very large homeowners insurance company in California who was sued because it was allegedly overinsuring homes. And that case ended up, a lot of money was involved, and the insurance company was basically penalized because it was allegedly overinsuring. So you have to understand that insurance companies are, in some sense, between a rock and a hard spot. On the one hand, if they underinsure the home, then Mike and his colleagues will go after them for underinsurance. If they overinsure the home on any sort of systematic basis, which I think is what we're talking about, because you just assume that costs are going to be higher than they actually turn out to be, then they're going to be subject to being sued for overinsuring. So it's very challenging because, like I said, a single fire is going to yield one reconstruction cost, and a catastrophic wildfire is going to yield another. So it's almost an impossible situation for an insurance company to ever not be criticized for something, but that doesn't mean that they're trying to act unfairly or trying to take advantage of the public.
Okay, and I think Gideon, you had a question about underinsurance and
Oh, I think you've addressed it.
Okay, great, and let's get into some of the effects of being underinsured, and one of them, I think, Gideon, that you did bring up is that the dealing with a bank or a lender. I know people who the lenders want they want to keep the money, especially like, for example, in a condo kind of situation, townhome type of situation, which gets more complicated than we want to get tonight. But what are some of the other effects of underinsurance? Mike or Peter, either one of you.
Well, back to what I said earlier, not being able to comply with the requirements of the policy that require you to rebuild or replace your property to its pre-loss condition, where you have to fund the delta between replacement costs and actual cash value. And that's just further exacerbated by being underinsured. So you create this catch-22 situation where you're never able to get the full benefit under the policy.
Well, it sounds like catch-22 applies in different respects to carriers and to insureds.
Right. And then, of course, the other thing is, and this has come up as a question in dealing with many of our clients, and I think it's a great question. It's also something that's never been yet addressed in any appellate decision that I know of, and that is,
Mhm.
if we're successful in an underinsurance claim of saying you didn't get it right when you set the dwelling limits,
Mhm.
many of these coverages, the personal property coverage and the ALE coverage and the other coverages, are set as percentages of the dwelling limits. So if you've underestimated the dwelling limit, then you've now also underestimated or given limits for the balance of them that are lower than they should be.
Right.
So that's going to be another issue that arises here as well.
And I can just tell
I'll
you,
add some.
oh, sorry, with my in-laws' home, uh, I mentioned we bought it 2 months before the fire. We put 20% down because they didn't sell their old home yet. They were going to sell their new home and pay down the remaining 80% on the loan. We didn't have time to do that because of the fire. So thankfully, they kept their old house actually. But so we have a situation for that house where there's a huge mortgage. The property does not appear to have enough in the insurance to rebuild it. We've been paid 60% of dwelling A and B, which can be combined in a state of emergency situations. But there's 35% more to fight over, Len. But it's still, even if we were to get that, way underinsured. So we're in a situation now. Why would we spend all the money and drama fighting for that extra 25% when it's still not enough to rebuild and it's all going to go to the bank anyway? So we're telling the bank, you go and deal with Sage Shore and fight for that remaining 25%. It's going to be your property. We may have to give the property back to the bank. We're trying to work that out with the servicer for Citigroup, who is Senlar. We can't get the right person on the phone. The property has been extended forbearance on the loan, so we're not in default yet. And they're telling us we're not going to have a discussion with you about the workout and how the insurance plays in until you're in default. So that's the situation we're in on the second home right now, Len.
Wow. Wow.
Right.
Well,
That problem that's exactly the answer to your question of what's the practical problem of being underinsured.
Let me also add that this issue of underinsurance it's very different from an issue of an insurance company not paying benefits that it agreed to provide. It's a totally different type of claim, different consequences, and I think it's handled differently by the insurance industry. So an underinsurance claim by definition is basically an argument that an insurance company should pay for something for which it never agreed to pay and for which it was never compensated to provide. And so it's very different from a claim for breach of contract or breach of the implied covenant. And if the evidence shows that the insurance company did the things that Mike walked you through earlier that fall under the case law that says that, basically the insurance company, essentially misled the homeowner into being inadequately insured, then the insurance company will be liable. And chances are, if that evidence is presented to them, that they probably will resolve that. But in most cases that I see, that's not the case. It's a situation where the insurance company was not the cause of the problem, but the homeowner is facing all of the problems that have been described here, and they're trying to point the finger at somebody so that they can get compensated.
Mhm.
And I'll simply point out that because it is not a type of claim involving the withholding of policy benefits that were promised in the contract, you cannot sue the insurance company for bad faith and the tort damages that you could potentially otherwise get if your insurance company withholds the policy benefits that were provided by the contract.
This is a very interesting issue, and I'm glad it came up because this is one that we'll be dealing with as well. And I'm sure Peter and other lawyers on the other side will have their arguments. And it is true what Peter said about traditionally the breach of the implied covenant, good faith and fair dealing, and insurance contract applies to delays or denial in the payment of benefits. I agree with him. But it's interesting that the same statute we've been talking about appears to have addressed that, because in subparagraph J, it says to communicate an estimate of replacement cost, replacement value, not comporting with subdivisions A through E of this section 2695.183 to an applicant or insured in connection with an application for or renewal of a homeowner's insurance policy that provides coverage on a replacement cost basis, constitutes making a statement with respect to the business of insurance which is misleading, and which by the exercise of reasonable care should be known to be misleading pursuant to Insurance Code Section 790.03. And all of us in this business know that California Insurance Code Section 790.03 was the codification of the earlier case law having to do with the obligations, and it's basically the 10 commandments of insurance claims handling.
And which is our next topic, and we're kind of running out of time. So I really would like to get into the claims handling issues. And one of the things that people have to understand is what's the scope of loss, and what do you do, Mike, to help your clients provide a scope of loss?
First of all, it's the carrier's obligation in conducting a fair, balanced, thorough investigation to come up with a scope of loss. And one of the criticisms we have on the plaintiff side is that many times, in particular in cases where people are underinsured, they're told, hey, you know what, we've determined that it's a total loss, so we're going to pay you the full benefit, and not even bother with giving you a scope of loss. Our position is that they should give you the scope of, because if they do it, they could very well come up with a number that's far in excess of the coverage, which then satisfies one of the prongs that we're going to be required to show for underinsurance. But we then urge people to get a legitimate licensed contractor that is willing to actually do the work for the price they put on the scope, and to get their own scope so they can compare what information they're getting, if they get information from the carrier, on the amount. And so you have to know what it's really going to cost, and you have to get it from a legitimate source, not someone who's just giving you a high number.
Mm-hmm.
Someone who's later willing to testify that they're willing to do the work, or by the time a case goes forward that they've actually done the work.
Mm-hmm.
Not just a hired gun to put out a big number.
And Peter, are there any problems with the scope of loss issue that you've been experiencing?
Yeah, I think that in these recent fires, I think because of the inflation that I talked about, there probably aren't as many disputes as there have been in the past. But in the past, when we didn't have the inflated reconstruction costs that occurred in the aftermath of a wildfire, there were a lot of disputes over what does it really cost to rebuild, and are you rebuilding the home that actually burned, or are you rebuilding a far better, more expensive home? And those were the types of issues that were the subject of a lot of these, what we used to call the underinsurance lawsuits that we had in the 1990s and 2010s. And so I think that it just comes down to both sides being reasonable. The insurance company needs to be reasonable. It can't try to get an estimate that's a lowball estimate that doesn't include all the things that are necessary to rebuild. And likewise, the insured needs to be reasonable and not try to rebuild something that is not consistent with what they had before. And I'm putting aside code upgrade issues because that's a separate category where
Right.
the policy may provide those additional benefits even though they didn't exist at the time.
And that some of those some of the issues relate on claims handling relate to whether there is a state of emergency, and I'd like to go through that very briefly if we could. First from Mike, and then from Peter, if you have something to say on that subject.
Yeah, the Department of Insurance put out a bulletin that for all the different categories of a state of emergency, minimum deposit on additional living expenses, extended time to do the rebuild. There's a whole litany of changes that everybody has to follow based upon the state of emergency. And there's a handout. If someone contacts us, we could send to them that lists all of them.
Okay, and we've covered some of them briefly in the two slides, basically. What one of the, if we go to the next slide,
And I'll just add, Len, these are examples of insurance company obligations that may not exist in the language of the insurance policy, but are imposed.
Thank you.
Outside, and so it is a special situation. I think that the DOI and the legislature has recognized that unique problems arise in catastrophic loss situations, and they're trying to address those with these statutes.
Right.
Len, can I present where I am on this issue and maybe just get a quick piece of advice?
Oh, okay. We got to make it brief, though.
Yeah. So my situation is Mercury has paid out 60%. Actually, they paid out the full dwelling A, and they're paying out a little bit so far of the extended replacement cost and the code upgrade. So I'm in the situation right now where they've done an exactimate, they've estimated what that is, and they've paid out a small percentage of the 50% extended replacement costs and the 25% code upgrade. So I have my dwelling A, and then I have 75% potentially on top of that. And they've paid maybe 15% of that 75%. So what I'm doing now is I'm hiring my own contractors to go out and estimate what it's going to be to rebuild a 115-year-old house that has burnt down, that everybody knows can't be rebuilt, and which I'm not going to rebuild the exact same house. But to find out how much money I have to go through this weird process of pretending I'm going to build the exact same house, because only then do I know how much money I have to either rebuild at the site or rebuild elsewhere for a house which the structure has an equivalent cost. So I'm in the process of this weird exercise, Mike and Peter, to pretend I'm rebuilding a house that even Mercury knows I'm never going to rebuild. Any advice on how to navigate that process, or is that just subject to maybe I negotiate that plus my ALE and try to figure out if I can just, instead of going through this exercise, just close this claim? Any thoughts?
You have to comply with the contract, even if you don't believe you're going to build the same house as your entitlement, your benefits have to be related to what you had before. And to restore your property to its pre-loss condition, you have to make it apples and apples. And it could very well be due to the age of the house. Number one, it wasn't genuine lath and plaster. And those costs can really elevate the replacement costs, but you cannot expect them to pay based upon that which you're going to build if it's not the same house you had before.
Right.
The policy has to be what you had before.
I don't mean to cut you off, but we only have about 5 minutes, so I really I think it'd be a great idea for you to talk off kind of after the presentation on this. But thank you for raising the question. the getting through the adjustment that we're talking about, we've had some of the discussion about ALE, fair rental value. So I think we're going to be skipping some of the ideas set forth in the getting through the adjustment portion of this, unless there's something specific that that any of the panel members want to raise. If not, I'd like to get to some short conclusions or takeaways that I'm going to first start with Mike.
Well, the old rule, when in doubt, read the policy. Your strength in dealing with your adjustment of your claim comes from a knowledge of what your policy says. You can't take for granted any general rule or one size fits all. You read the policy, familiarize yourself with the provisions that the DOI has saved for the emergency, so you know what your rights are. And then, of course, be sensitive to the fact that everything we discussed about underinsurance. And certain people have had success in seeking a voluntary reformation of the contract. Believe it or not, some carriers I've seen, without legal representation, people have actually gotten carriers to, on a few occasions, to increase the limits based upon the evidence they submit.
Thank you. Peter?
Okay. Well, I'll just say that for the benefit of the people that don't know people that work in the insurance industry, you may be surprised to learn that a lot of them, most of them, are very kind, caring people, and they actually care about these homeowners whose homes were burned. And because of that, my recommendation would be, when you're dealing with the insurance company, deal with them professionally, politely, because if you come across as being somebody that is unfairly critical and treating them in a very unprofessional way, it's not going to make them maintain their desire to want to do everything they can for you. And also, when there's subsequent litigation, because those types of cases usually do end up in litigation, I found that those cases are a lot easier to win when the homeowner and or that homeowner's attorney were acting unprofessionally and unkindly in processing the claim. I think that both sides need to act reasonably and fairly, and that's how you avoid litigation.
I agree with that 100%. There's nothing worse than a nasty email or things of that nature. You be cooperative and professional throughout. Even if they disagree, do it in a respectful fashion.
And Matt, you want to offer just a couple of comments? We're very little time. I'm sorry.
My comment would be, if there's any lawyers or any non-lawyers watching this who don't really deal with insurance policies, if you read it and you can't understand it, you're not alone. You talk to a lawyer who really understands what's involved in these policies, so that you can have an understanding of what you're entitled to.
Thank you. And Gideon.
Yeah, I'll just tell an anecdote, and it may not be appropriate for everybody, but it's been important for me. One of my friends also lost her home in Altadena. She's a lawyer in her 60s. It was the craziest day of her life. She was the next day at an Airbnb in Monrovia. She's got ash in her hair, mismatched flip-flops and shorts on from the evacuation. She's just trying to gather her thoughts. There's a Keurig coffee maker in the Airbnb, so she grabs a coffee cup out of the cabinet. It's the first cup that she takes. It's in one of those embossed coffee cups, Len. She looks at it. It says, "Let the adventure begin." And that's the spirit with which I've been trying to take this over the last 9 months. And I found that anecdote, during the dark times, helpful for me.
Thank you. And I want to thank everyone who participated in this, and I thank our audience for tuning in. We hope that this is something that contributed to your understanding, a better understanding of the issues involved. And thank you, Michael, Peter, Matt, and Gideon, for sharing your experiences.
ADR Services, Inc. has been your unwavering partner in alternative dispute resolution. But as the world changed, so did we. From virtual and hybrid hearings to our ongoing on-demand CLE program, ADR Services, Inc. continues to keep resolution and legal education at the forefront. Woman-owned and operated from the start. There is someone for every situation. We are ADR Services, Inc.